Okay, just as normal class per se, I hope with you, you are going to have this Contract Acts as well as Specific Relief Act 1950 with you, because these two statutes will be our major reference during the class itself. All right, because contract laws in Malaysia, unlike UK law, it is a codification of statute. Whatever is it in regards to contract law, we must refer back to Contracts Act 1950. It's very important for you to get familiarized with this statute. So I just want to make some disclaimers before we go on. I'm just a very junior lawyer. I may not have be able to cover all the areas of laws in this class per se. And this is, of course, a pro bono class in which it is free of charge and there's no consideration in between us. And I cannot guarantee, as always, the information of the lecture could not be guaranteed. And I will very much appreciate your constructive opinion and feedback on my teaching methods and whatsoever that I can do to improve my future class. Okay. To talk about contract, we cannot run away from the reality that you are CLP students. Most of you here are CLP students and you are required to pass the examination. So in which to say, contract itself form half of your general paper. And general paper is one of the paper that you require a lot of skill set, whereby you need to learn how to draft your statement of claim as well. All right. And I will really encourage you to practice a lot in a manner to draft a very proper, cautious statement of claim as well as contractual statement of claim. Okay, and the time management is very important because these are the major loopholes that a lot of candidates will fall into when they are preparing for CLP. It's not because they do not have adequate knowledge, but rather they did not have time or did not have a proper time management to complete their answers. So do not attempt to perfect your answer most of the time, but rather than you must answer all questions. That is most important. So please have a proper time management during examination. Okay. Okay. In terms of this lecture, we aim to cover these two. Question 2A and question 2B of your general paper, whereby we will usually discuss what are the causes of action that is available to a certain individual as a contracting party, as well as what are the remedies that is readily available to him, okay, or her, according to the scenario given. Okay. So how do we approach a question? This is very important. You must read the question for at least 2 to 3 times before you attempt to put an answer. I repeat, please read the question for 2 to 3 times before you attempt to answer the question. Otherwise, if you do not read the question properly or you do not understand the whole scenario given properly, all I can say is probably there's a chance or possibility that your answer may be totally deviated from the right answer. That means there is a chance for you to get 0 mark for that particular question. Don't ask me why I know that. Because I'm already in practice and I'm teaching CLP. I got some friends that gave me this sort of information. Please. And steps. There are steps that might be able to help you or beneficial to you in the sense to dissect this question properly. Number one, you have to identify who are the parties, who are the plaintiff or who are the defendant. and which party that you are representing. Because as a practicing lawyer in the future, your task is only confined, or I would say your responsibility will only be confined to the party that you are representing. So your arguments will be always in favor of the party that you represent. Usually, the question given from the years that I have gone through is all about plaintiff. You will be acting for the plaintiff, okay? Unless otherwise stated in the question lah. And you must also identify the limitation period, whether this is, I mean, if it is a cautious question, I mean, top question, particularly, you have to look at your Civil Law Act Section 7 dependency claim, as well as Section 8, whether this is run out of time. But of course, when we talk about contract, the only, I mean, if we are suing what we call private party, not government, private party, usually Limitation Act 1953 will be the one that define what is the duration that we can still have the rights to sue. Otherwise, you will have to read your papa lah. Okay, if let's say this is a government hospital, for example, then the limitation will be different. Okay, and what is the top jurisdiction? Okay, for most of the time, contract question is very uh, usually more than 1 million. The monetary claim itself will be at the jurisdiction of High Court. Hardly they give you some claims that is less than 1 million. So you can practice in such a way that you draft your statement of claim in the what we call the High Court of Malaya at so and so place. Okay, so usually High Court. And today we are going to spend a lot of time and energy to discuss about the elements of contract. We have 7 elements. This is according to the textbook that I have referred to. Okay, 7 elements of contract. We have to look into some aspect of contents of the contract, our next lecture, and discharge of contracts by way of you have duly performed your obligations under the contract, or there's a novation order, something that you add in to vary the contract. This usually what we call as a variation order in construction agreement. And whether you have rescind it, then you don't have to do it. Okay, or there's a alteration of a contract, frustration, all that we'll discuss in our next class lah. And what is the damage that you are suing? Okay, and other minor collateral issues will include of the extrinsic evidence, whether oral agreement can be introduced if you have a black and white agreement. So this is one of the popular question that they ask also. No doubt this is one of the evidence related question, but somehow or rather they love to question it in general paper. Okay. Again, I would reiterate that contract law in Malaysia, unlike UK, it is being codified in Contracts Act 1950. Okay, very important. If you have a statutory reference, by right, all your answers should be directed towards the relevant proviso inside this Contracts Act. And apart from that, you must also look at your Specific Relief Act 1950, which provides you the rights to rescind the contract as well as to do some sort of specific performance. That is to say, injunction, if it is ever required in the question. And later on, you can look at your case law. Do not jumble up the structure that you analyze the question, because as a practicing lawyer, I can tell you responsibly that this is how we submit how we make our submission. We don't look at the case law itself, because case law itself usually will evolve by time, because this is court interpreted case law. this case law is only helpful to assist you, to aid you, to let you understand better how this statute or how this relevant proviso in contract act operates. Nothing else. It does not replace the contract act. So you must always refer back to your contract act. And English law shall only be introduced if there is no provision in our law or there's a lacuna in law. This is very hard nowadays to import English law. Having said so, why? Because Malaysian had been independent since 1957, and I was not even born that time, you see. So uh, we have been independent so many years, and of course, our court exists for a reason. We do have precedents for most of the case law now, and for most of the disputable area of laws now. So very hard for you to just write out your what we call English law in your answer. So you must learn Malaysian law. Okay. First and foremost, before we go further, you must understand the rationale behind why we have law governing the contract. So contract is what? Contract is a valid and enforceable agreement, usually entered by two parties. No doubt it can be unilateral contract, but usually two parties to run a certain transaction, particularly in commercial transaction. So in this current world of capitalism, contract is very important to ensure the social order as a whole, because we have a laissez-faire, this what we call doctrine of law, whereby we have liberty to own property, we are free to enter contract, and there should be minimal intervention from the government. So that's why the contract law is very important, but it's somehow or rather related to some equity principles. That is, every party, so long the contract is itself is not so, I mean, not illegal per se, you are free to enter into any contract that you want, provided it is legal in the eyes of law. And we must respect the sanctity of the contract. The contract itself is so-called very holy instrument. That means to say you enter the contract, you cannot simply go back to your word. You cannot simply breach it. Otherwise, how do we maintain the social order? You get me? Bear in mind, equity shall always prevail. Okay, that's why you have a subsequent proviso that support these two very important principles. So how many types of contract we have? For the exam per se, you just need to know bilateral contract because eventually you are required to draft a statement of claim here. But just bear in mind, we have unilateral contract whereby a person can enter a contract with the whole world. That means to say is that there is just our classical case would be carbolic against Carlier against carbolic sport ball, whereby the said company had been adjudicated as such that it had entered contract with the whole world. Uh, uh, because you see, this is obviously an advertisement, but somehow or other the terms are binding to those who are interested to enter or to buy their products, but find their products is unuseful or useless. So they can actually sue the company. So even though there's no so-called agreement, say that I sell this to you, yes, I agree to buy, but somehow this is the landmark law. But I don't think we use it a lot in our practice. But it's fun to know. So bilateral contract is, having said so, usually more than two parties. No, sorry, not more than one parties. That means to say at least we have party A or B or even party B, C, D, E, like that. They enter into a promise and there's some exchange of return, which we have a legal term for that. That is called consideration. Okay, we'll discuss it later. And we also have collateral contract. Collateral contract means that you have one main agreement, but subsequently, you have another contract that exists side by side with the principal contract. For example, the classic and landmark case in Malaysia would be Tan Chong Motor against Alan McCline, whereby Mr. Alan here is an Australian. He wanted to purchase a motor. Okay, I presume this is Nissan because Tan Chong is the sole distributor for Nissan that time. So he bought one car. So the principal contract itself is a sell and purchase agreement over a car. But subsequently, the terms inside did not say that the car shall be able to be exported or imported by government of Australia. But then the sales representative of Tanjong Motor did represented to Mr. Allen that, oh, this car from Malaysia, isn't it? You buy, subsequently you can export lah. I mean, to Australia. Australia immigrant custom will have no issue to take the car. So it forms a collateral contract here, even though the main contract itself is just about the sale of a car. Okay. And elements of contract is particularly important because to form a contract, I said to you, contract itself is a legal, valid, and enforceable instrument. So the completeness of the contract is very important. Otherwise, it will not be a contract. If it is not a contract, then Contracts Act shall have no application towards this paper. I would say it's a paper lah, because it's not a contract. So we are going to look at 7 elements which form a lawful contract here. Number 1 will be your proposal. Okay, in English law, okay, you learn this as an offer. But in contract law, I mean Contracts Act 1950, we have a proper definition. We use the word proposal for this. Okay, so make yourself a little bit more stand out as compare your peers. Write the words that is provided by statute. I think that will outshine your other peers lah. And second thing, the said proposal shall be accepted by the party, the other party. And number 3, there shall be some sort of consideration. Okay, we'll discuss about that. What is the consideration? In Malay, we call it balasan. Balasan. Apa saya dapat daripada kontrak tersebut. And number 4, there must be an intention to create legal relationship between the parties. Usually, it is a prima facie, whereby if you are entering a contract for the purpose of business, commercial transaction, not domestic purpose, not between brother, sister, all that, it is deemed to have such intention to create legal relationship. And the parties that enter the contract must have adequate capacity. That means to say he or she is not a minor, or he or she is not of unsoundness of mind at the material time to enter that contract. And because we said that just now the equity principle is two things. What you are free to enter into whatever contract as you like, freedom to contract, and the contract itself becomes so holy that we must respect the sanctity of the contract, isn't it? Therefore, the free consent or the willingness, voluntariness of an individual or a corporate whatsoever, a party that enter into a contract is very important. So we have issue that might reshape the free consent here. And last but not least, legality of the contract. What is the purpose of the contract? Will the contract eventually be caught by some law, making it unlawful? For example, I contract with you to sell a package of heroin, 1 kg. It is a commercial, but in return, I will pay you 1 million ringgit, for example. So you look at the contract at the end of the day, it's about the sale of illegal drugs. So legality of the contract is disputed. So there's no contract. You get me? Okay, we'll discuss about that. So we have a tongue twisting section 2 here, whereby I think everybody should know. So section 2, subrule A, provides that when somebody offers someone uh, a thing or whatever to enter into an agreement, this is called as a proposal. If the proposal is being accepted, it is called promise. Okay, I promise you. But at this stage, you must always remember it is not yet enforceable in contract law. It's just a promise. For example, a promise to marry. Okay, but we have other laws that say this is enforceable. I don't want to confuse you. And we have promiso and promisee at this stage. And subsequently, what is the consideration here? What is the balasan? Balasan in the English word is called consideration. It refers to what are the rights. The rights, what is hak? Okay, interest, profits, or benefits that one party will get by entering into such an agreement. Okay, take for example, I teach you this CLP class. Okay, for 1 hour, you get 1 hour of lecture from me, and then in return, you pay me 50 ringgit. So this is what is your consideration? You get 1 hour of lecture. So what is my part of consideration? I get 50 ringgit in return. So this is an agreement already. If it is coupled with apa nama consideration. Okay, so please bear that in mind. So because having said so, I do not get any thing return. So our whole lecture, if anything goes wrong, cannot be enforced in the eyes of law. Okay, you get me? And uh, we have reciprocal promise as well. So that means to say, let's say promiso, love promises, and promisee must love the promiso back. We call reciprocal promise. This is usually how the contract should work. It go one round. I give you, you must give me back as well. Okay. And section 2G, you have agreement that is not enforceable by law. You have to read this section with your section 24, especially. Okay. So when the consideration itself is somehow rather unlawful, okay, I give you one example. I engage you to kill my wife. In return, I will give you again 1 million ringgit. So the consideration, the purpose of the whole thing is about you have to execute by murdering my wife. Only that you'll get 1 million ringgit. Am I correct? So this thing, murder is not allowed by the law, obviously. So this is void. Okay, so section 2G. There's a specific interpretation there. And like I say, if the agreement here, you see, 2E1, if it is enforceable by the law, there's no issue with our 7 element that we have discussed, which is there's no issue of illegality here. It shall be called as a contract. A contract is an instrument which is legal, valid, and enforceable in court. Okay. And section 2I, if it is only enforceable by one party. Okay, take for example, if let's say there's something to do with affecting the free consent. There is a fraud, for example, there's a misrepresentation. I feel my part got cheated lah, in a layman term, got cheated, and then I got induced into signing this contract. So the contract brought by this the plaintiff to sue me because I breached, I don't want to execute because I feel I was cheated. So that one party wanted to enforce, but I did not, I refused. So this is called voidable contract, voidable contract. That means to say the contract is void plus able, so can be voided. That means like that. Okay, that means to say the court has the power to cancel this contract in totality. And section 2J, agreement enforcer, let's say for example, if this agreement is not enforceable by law, I think this one got some error with section 2I here. Okay, it says here, an agreement which is enforceable by law at the option of one or more parties, but not the option of the others, is a voidable contract, right? And J, a contract which ceased to be enforceable by law becomes void when it ceased to be enforceable. That means to say, when the law said it is no longer valid, for example, I give you one example, it's like Franchise Act. Okay, Franchise Act is a very specific act which govern the franchise agreement, whereby you have commercial agreement, and subsequently we have a new amendment 2022. Okay, let's say the amendment said that the registration of foreign master franchisor must register, but they did not do so. But usually franchise agreement will last 10 to 20 years. If they do not register within 5 years, then the agreement itself cease to be enforceable. Therefore, you will have cause of action that the whole contract itself is void. Okay, so this is what it is meant by your section apa nama 2J. Okay, be clear, be clear with all this definition first, and familiarize with yourself about this tongue twister. Okay, so elements of contract very important. Proposal plus acceptance form a promise. Promise plus consideration, you get something in return. You call that an agreement. Be very, very, how do we say? Be very, very clear cut in your wording because every word is challengeable in court. Okay. And if all these 7 elements are fulfilled, you can label that as a contract. Otherwise, it will be an agreement. So when you answer the question, maybe in May or June, we'll discuss the question. So I will draft you a sample of answer where you which stage you put this is an agreement, this is a contract, something like that. You cannot say everything is an agreement in your answer. Okay. If I make one thing very simple for you, every word is very important in contracts act. And if it disturb the element of number 6 and 7, that is free consent and legality of the contract itself, it will be void or voidable. Usually free consent is voidable at the option of the party that suffer so-called damage. And whereby if it is an illegal contract, usually the contract itself is totally void at initial. That means to say from the beginning, it cannot be exist like that. Okay. We'll talk about proposal first. Proposal is the willingness to do or abstain to do something. Okay, so very simple. This one, no much issues that you need to be concerned about. And usually, examination per se, isn't it? You do not need to waste so much time. Yes, this party offer this, but, because this is usually not so simple, our contract. Usually, our question will be evolving with the issues of free consent and legality. Proposal acceptance, yes, but briefly. No need to talk about that in detail. Okay. And proposal itself has got four issues. You just remember it shall be distinguished with your preliminary communication, and also this ITT means invitation to treat lah, something that you display in your catalog or your this is English law also got what case is it? Pharmaceutical books one case here. You put your medicine into the rack, so it just serves like invitation to treat. Whether you want to buy it or not, it's up to you. Something like that. Okay, it can be oral or written, and it can be made to a specific person or even to the whole world, as Carlier against carbolic smoke ball suggested so, and it shall be communicated. Okay, very important. It must be told. The information must reach the opposite contracting parties. Otherwise, how to know? Okay, very clear cut. Okay, and the revocation of proposal is um, being laid down in your section 5 sub rule 1. So that is before the acceptance, the proposal itself could be revoked. Otherwise, why this one is quite important is sometimes you want to suddenly cancel the whole deal. Okay, so it shall be done before the opposite contracting parties accept the deal. Otherwise, it will be deemed too late. Okay, so four conditions for the revocation of proposal. The promisor is itself must issue a notice say that, oh, I don't want anymore before uh you accept, because it will take some time for the contracting party. Take for example, I need 1 week lah to think about that. So within this week, you feel that the deal that will not be benefiting to you. It calculate wrongly. By right, this contract to renovate your house shall be costing about 200,000, but I only quote you 150. So I quickly issue a notice say that the previous quotation cancel lah, cannot. Okay. Or some people they are smart enough, they will say the validity of this quotation will only last for a month. If not, it is lapsed. That means to say it is no longer. You cannot use this quotation like you see Malaysia suffer from inflation, isn't it? You use it after 3 years. Hey, I want to accept this deal lah, 10 years ago. Ah, the quotation you have given me 10 years ago. So now I accept it. Can or cannot? Of course, it will be caught for the lapse of time. And the condition precedent, if it is being offered, okay, take for example, I will enter with you this contract provided you give me, take for example, it's a renovation of the house, but you also give me the renovation of your factory at the same time. So this form a condition precedent to the acceptance. Okay. And obviously, when the proposal is dead or suddenly become crazy, I mean, prior to the acceptance, then the whole thing could be revoked. But not so important, I would say, for the purpose of accept. Acceptance means the other parties agree to the proposal. Simple as that. Okay. So there are four issues that in regards to the uh, acceptance itself. The acceptance by right should be absolute and unqualified. That means the other party offer, I renovate your house for for example, 200,000 ringgit, then the other party will only say yes to it. That means to say the acceptance itself cannot add some new terms or subjected to a certain condition. So this is what it means. You cannot say that I accept the deal, but there's a but there. Tetapi saya minta kurang sikit harga. I quote you 200,000, you quote me back 180. That is not acceptance anymore. That is counter offer. So get your um, principles right. Okay. This is governed in your section 7 subrule A. And subject to contract means, let's say, for example, usually it is not as simple as it sounds. Nobody will just sign a black and white contract before some sort of negotiation happens. So this is reality. Everybody is becoming more and more aware of the law and also their own so-called personal liability. They are watching their back as well. So usually before a contract or an agreement is signed, they'll have a series of discussion to finalize the terms, to finalize the price, usually the price lah. Okay. If let's say, for example, the other parties at the end of the meeting shake hand, they have a deal, okay, but it is subject to contract, then the courts will need to look what does it mean by the word subject to contract? Does it mean you already concluded these are the terms and conditions already during that final meeting? You already conclude everything. So subsequently, you just put it down in black and white for the parties to sign. So this is different. Okay. Or subject to contract means there will be a new, I mean to say both parties shake hand nicely, say that subject to contract, but the other parties appoint a new lawyer to advise them to draft a new contract. That will be different issue as well. So you have to look at it properly. What is the situation? Is it all the terms settled already during meeting? Or subject to new contract? Or that is to say further discussion. So that means there's no contract at all at the final meeting. If the final meeting is already concluded, every terms and condition, that means there is already contract existent, even though it's just by verbal manner. Okay, so you can make a distinction between the case of Loh Kayit against Muhammad Isa and also Charles Grenier Sendirian Berhad against Lau Wing Hong here. Okay, very important. Uh, and what are the third issues? What are the methods of acceptance? Usually, you can do it with by conduct means you perform the contract, or you can agree by orally, but orally very difficult to prove in court lah. And electronic means or documentary manner, you can do it so. Okay, and silence usually cannot amount to acceptance, but subjected to case law. Depend what is the gesture of the contracting parties at that moment of time lah. Okay, and obviously, acceptance shall be communicated to the uh, proposal, the one that proposed the agreement to you. Okay, and this is relying to your section 3 as well as section 4 subrule 2 of your contract act. Okay, and usually nowadays we rely a lot with electronic commerce act 2006. People will reply by email and apa nama, WhatsApp whatsoever. So postal rules nowadays very hard, very rare we use it in practice. Okay, and the acceptance can be revoked before the communication complete. Okay, nowadays very difficult, very difficult. Like I say, we have a instantaneous messaging, email, all that you receive on the day. How you want to uh revoke? You just need to pray hard lah. The other party did not open their email. But let's say you WhatsApp to them, and then there's a two blue there, the communication is already been complete. So acceptance cannot be revoked anymore. Okay. So consideration to be our next elements. So what is actually we call as consideration? Like I said to you, it means the rights, benefit, interest, or whatsoever profit that obtains by party after entering into the contract. Like I have given you the example, I give you 1 hour lecture. In return, you pay me 50 ringgit. So your consideration is 1 hour. You get some knowledge, hopefully, at the end of the class. And at the end of the day also, I will get 50 ringgit from you. So both party has got consideration. There are actually three types of consideration here. First one, past consideration. Past consideration in Malaysia is enforceable. That means to say, I give you one straightforward example. Chi done a pro bono class. By right, should be a lecture class lah. So after the class, Gan felt that Chi is doing a great job and he gave me this 100 ringgit. So I accepted this 100 ringgit. So this is considered as part the consideration. We pay you by passing the main paper. No need. I'm doing it for my karma. Okay, so past consideration means section 2, rule B, as well as your section 26, sub rule B. Please remember, for something that actually, Gan and Chi did not have a prior contract, before the class. So I already did my part and I don't expect from you, isn't it? But you pay. So after you pay, I can actually rely this class I do. Otherwise, you do it in a manner that, okay, this Chi actually 100 ringgit is not for the class because this thing is past already what. Sudah berlaku what. Ini 100 ringgit apa tujuan? Pinjaman pribadi. So a lot of case we have seen whereby people done their works and then get paid later. So they call it the payment is not for the contract but personal loan. Oh, habis you have to repay you back. That is not fair later on. So executed consideration. Executed consideration, you can see a lot like missing cat, my wallet is missing, and then I advertise in Facebook. Okay, I give you one ang pao lah, 888 ringgit if you find my cat. And then Gan subsequently found the cat and returned to Chi. So you see, this thing here, I contract it out, but I did not appoint Gan to find the cat, but isn't it? Gan found the cat by his luck lah, or coincidence lah. And this thing can be enforced, by Gan. Because I found the cat. You see or not? Gan found the cat. So I have to give Gan a. I cannot just say thanks, goodbye. Okay? And executory consideration. Usually this is what the commercial world is like that lah. Okay, you look at section 24, illustration A, and it is by the wording of the statute that A agrees to sell his house to B for 10,000 ringgit. So B's promise to pay 10,000 is the consideration for A's promise to sell the house. And A's promise to sell the house is the consideration for B's promise to pay the 10,000 ringgit. These are lawful consideration. So again, Englishman, tongue twisting. So you just have to remember, B will get his house, isn't it? And A will get 10,000 ringgit from B. These are already considered reciprocal. Saya dapat rumah, you dapat 10 ringgit, 10 ribu ringgit in return. That's it. Ada ulang alik, reciprocal promise. So this is usually what happens in commercial world, and we call it as executory consideration. Okay, very simple. Okay, so this is what is it lah. Okay, A sell the house, B pay apa 10,000 ringgit. Okay, um, we have a few principles, three principles and one exception. This one very super duper important, okay, because it is often being asked and tested in question. Section 24, you must a little bit, no, you must not just a little bit, you must know this provision in detail. Okay. Section 424 subrule A said that if let's say this if you look at the heading here, you look at your section 24, it said that what consideration and objects are lawful and what not. Okay, that means to say it has something to do with the dispute area, whether this contract eventually is caught by any law or not. If A is forbidden by any law, then the consideration shall not be lawful. And B, let's say there's no clear-cut law say that it is wrong, but somehow or other it will make the the law, it will defeat the law if it is allowed. Take for example, Marong Mahawangsa against Datuk Sazri SK case. The fellow here is charging consultation fee to the company in Hana is Hana is what? It's like smart Hana thing, It's a highway lah, something like highway, but you have to build a tunnel for that. But somehow or other, the consultation agreement, by just one glance, it will look like lawful. But if we scrutinize the consultation agreement, it will involve his connection with minister, in order for them to get the tender. Okay, the project lah. Mau dapat, you appoint me as a consultant and I will run the works for you. I advise you how to get this project or tender by using my connection with the minister. By one glance, it is okay, isn't it? It's just a consultation agreement. But if it is allowed, it will defeat the law. Okay, so this will be caught as an illegal agreement and it will be void at initial. Okay. C, if it is fraudulent in nature, if it is meaning to say the contract is being formed for the purpose to cheat investor. Usually this sort of contract, we see it a lot in the franchise. Open a cafe with you, but that you put all the money in Sendirian Berhad and then resign. But subsequently, the cafe will never be formed and then I'll run away with your money. So this is fraudulent in nature. So it cannot be hold by the court lah. Or it involves or implies injury to the person or property. Okay, take for example, I contract with you so that you can sabotage my property. You go and burn my property. You go and spray some red paint inside my on the signboard of my law firm. Okay, can like that? Of course cannot. Okay. Or E, the court regards it as immoral or opposed to public policy. So whenever you feel some contract is a little bit fishy, if you are quite good in your law here, if you can use this section 24, you can play a lot of wonder. Trust me. Okay. And the consideration itself must be sufficient but need not to be adequate. So sufficient means that there must be doing something in return, okay, executory consideration. It needs not to be adequate is because this is a free world. You can enter into a contract. I can charge you 100 ringgit for the class. I can also charge you 10 ringgit for the class. It's up to me. So the adequacy part is not something that should be arguable in the eyes of court. Okay. So I give you one scenario. I sell my Rolex watch to Christy. my partner for 8 ringgit. So there's a return. Christy got the watch, I got 8 ringgit. So whatever subsequently I regret because I think the time I was not thinking straight or uh so I cannot subsequently argue that this is void for, you know, insufficient consideration, because the price is way too cheap, isn't it? 8 ringgit, you cannot buy a Casio watch. So cheese consideration was freely given. Is there a good consideration? At the end of the day, yes, I get 8 ringgit. That's it. Okay. And the consideration can move. This is also one of the favorite question that love to be tested. It relate to your doctrine of privity. Doctrine of privity means whoever that sign and agree to the contract will be the parties of the case. Take for example, Chi and Gan sign a contract. Okay, this contract is about make it very simple lah. It's about engaging Gan's legal service here. So only Cheese and also Gan's name is inside the paper agreement. Okay. So Christie obviously is the third party. So if any breach occur, for example, Gan does not want to execute the contract or there is some breach of the terms of that particular contract, Chi can only sue Gan. You understand? He cannot sue Christie, he cannot sue his wife, he cannot sue other people that connected to Gan. But whereas the name or the legal entity is not inside the contract. So this is what it meant by doctrine of privity. Okay. And if you look at this apa nama, section 2D carefully, the consideration actually can move. Okay. How I can sue Christie is, take for example, this is a construction contract. I appoint Gun as a main contractor. Subsequently, Gun as a main contractor appointed a lot of subcontractors, inclusive Christila, Miss Low, whosoever lah, to do M&E works, to do piping works, okay, etc. So if let's say this thing goes like that, probably you will have a chance to name Christie and Miss Low as um as the defendants of your suit. Okay, if let's say the consideration does move away, okay, but still the court approach a very strict approach whereby you can only sue the party inside the contract. Okay, so doctrine of privity as per English law is upheld lah. Okay, but unlike English law, Malaysia does not have this contracts rights of the third parties act. You can only rely on case law, Kepong Prospective against Smith, whereby doctrine of privity uh, is a general standard of Malaysia. Okay, so section 26 here, agreement that is without consideration is considered void. Okay, that means to say if there is no return, there's no tak ada balasan langsung. I don't know what I get from the one simple example is to teach you lah. I don't know what I get also. I don't get money. I don't get the respect whatsoever from you all. Then it is a void agreement. You cannot take me to the court suing me for being a lousy teacher. There are cases that students, in fact, took teacher, you Google and see, for lousy teaching and always ponteng, never teach them. So they successfully claim their damage. Okay. So unless okay, the said agreement is in writing and registered. Okay, love and affection, for example, we have the case of Tan So Sim here. Okay, this is a probate case if you are interested to know. Okay, and B, promise to compensate for something done, like I say, past consideration. Okay. And it shall be subjected to voluntariness and legal compatibility. Okay. And promise to pay a debt barred by limitation law. You know, if let's say, for example, you owe me a certain of amount of money, but subsequently the limitation act 6 years have lapsed, you cannot claim anymore unless there's a fresh acknowledgement of the said debt. This is subjected to your section 26 and also section 27 limitation act to be read together. The acknowledgement itself must be an emission from, let's say, Chi Ogan 100,000 ringgit, but 6 years already passed. So subsequently, she must admit, and also acknowledge to Gan, yes, I indeed owe you 100,000, but it must be in writing also, section 27. Otherwise, Gan cannot sue me in court because of limitation act. Okay, so this is always and also being highlighted in your section 26C. Okay, promise to pay a debt bar by limitation act. Okay. Mm. And intention to create legal relation. I think I have told you there's no provision in Contracts Act that say that you must specifically put a clause saying that, oh, there is a genuine intention to create legal relationship. There's no need. But you can see we see judgment inside the case of Kajang Sri Rocks products against Maybank means that usually if you want to enter into a contract, they must have some sort of intention to create legal relations. Otherwise, it does not make sense. Okay. So generally, there are two stages of test shall be considered. Like I said to you, any business agreement, any commercial setting punya agreement, there is a presumption. Okay. It is deemed to have intention to create legal relationship, okay, whereby social agreement between kawan lah, between keluarga, no, there's no presumption, okay, to create legal relationship, okay. And fifth element of the contract is the capacity, whether you have capacity or not. So you must look, whenever you discuss the capacity, you must look at your section 10, Section 11 and Section 12 of your Contracts Act. Very important, eh? So Section 10, Subrule 1 said that you must be a competent party. That means to say you gonna other competency lah. That means to say you must have the legal standing or legal competency in order for you to be a party in a contract. Okay, so three conditions be stipulated inside your section 11. Okay. Section 10 is just a brief punya definition, the section for uh, uh, about the complete capacity of an individual to enter a contract, whereby section 11 is the specific conditions that define who are competent to enter into the contract. It is provided that you must be a person that more than 18 years old. So you can cross-refer to your section 4 of Age of Majority Acts. Okay. So this policy is very important to protect minor. Okay. Protect minor because minor, they are not mentally matured. So whatever you say that there's a freedom to enter contract, and then after enter the contract itself is holy and must be upheld. So what if there is some fraudulent party that induce a 17 years old boy or girls to enter into a contract to sell their supposedly inherited bungalow or car? Not fair, isn't it? So age of majority must be more than 18. And at the particular time, the person must not be crazy, must be sound of mind lah, must not be something wrong there lah. Okay, and the person must not be disqualified from contracting by any law. That means to say, if what is usually disqualified is the person is not fit to enter into contract without usually bankrupt lah. Bankruptcy individual, we are quite scared lah. Okay, because whatever they do, they must report to the DGI, the then Director General of Insolvency. Okay, so that means to say this sort of contract entered sometimes cannot be enforced in the court as well. Okay, so we have several interesting case law just for your information to know about the effect if you contract with minor. Okay. Mohori Bibi against Damodas Gos and Indian case law, land case lah. So whereby it affirms in also the case of Tan Hee Juan case, you can see it in your land case. If let's say, for example, like I said lah, I purposely cheat you, 17 years old boy, to sell your bungalow or whatever land to me. But this contract itself is void, cannot be enforced, I cannot eventually register the land because it is not a valid contract because the contracting individual is a minor. Even though I have paid you the money. Take for example, Tan Hee Juan here, I paid Tan Hee Juan 100,000 ringgit, but he's a minor. So I can't even ask back the money subjected to unjust enrichment principle lah. Okay, so there are four exceptions whereby you can enter a contract with minor, that is contract to marry, okay, and scholarship agreement. Usually scholarship agreement, I think the government had learned their lesson because there are people that from 5, the SPM, they are just 17 years old, and then they score 9 A's, subsequently enter into a contract, bond with the government lah. You give me scholarship, I work for you 10 years, something like that, or I repay you a sum of contract. But before this Amendment Act, all the contract is void, We have one Revocation Singh against University Malaya, if I'm not mistaken. Okay, that one is a landmark case. So nowadays, scholarship agreements can be enforceable. And if it is Section 13 of Children and Young Person Employment Act 1969, 66 can be enforced. Usually this applies to what we call as the time waiters. A lot of cafe, they have school leavers, the SPM, or even from 3, from 4 during school holidays, they will, go and do part times. So there is a contract between the employer and employee. Insurance as well. Okay. So remedies that can be caught is only section 69. Okay, 69. Okay, very important. Okay, section 69 mean, let's say I contract with minors. Okay, I already pay you 100,000 ringgit, but eventually, because the contract itself is void, and then you refuse to give me your bungalow, so I lose 100,000 ringgit. So what can I claim back? Nothing except section 69, necessaries, station of life, food, clothes, relevant services. Okay, so this is usually applicable in terms of scholarship agreement. But bear in mind, now not all illegal, what we call, not all illegal contracts are, uh, let's say, for example, you lose something, you have other remedies, you have a unjust enrichment principle, you have your Patel against Mirza case. Of course, I think I will discuss it later lah, not now lah. Later on, you will likely confused. Okay, so now what we need to talk about is the sixth element of contract, free consent. So free consent here is governed by yours, again, section 10. Section 10, don't be just think that it is only regards to the capacity, but it also has something to do with your free consent. Because in order for you to be competent, it's not your age matter, but then your willingness to enter into that contract is also a crucial consideration by the court as well. Okay, so this is provided in your section 10, 13, and 14. Okay. So 13 provides for your uh, consent. It means that two or more person are said to consent when they agree upon the same thing and the same sense. That means both of you are not misunderstanding each other. Take for example, I said I want to give you class at 8 p.m. but I did not mention the date. I just say today. Today could be depends on whenever you read the message lah. Today it could be for you that read the message tomorrow. It could be on tomorrow. What isn't that so? So there must not be any misunderstanding. Okay, must agree with the same subject matter and also same sense. Okay, section 13 refers to two or more person. Okay, it cannot just come from one person. You cannot say that I already got your consent, but actually the opposing party never agree. So where is the consent come from? Consent must be done by two or more person, and the said consent shall be a free one. Free consent does not mean it is not coming with money, but it is free will. Okay? That means to say the contracting party voluntarily, willingly, without any of the so-called vitiating factors under your section 14A to E enter into contracts. That means to say the party must not under any coercion. Coercion means paksaan, terpaksa, dipaksa. I have no choice but to teach you. So I'm under coercion. Okay. This is under section 15 as well. Okay. And undue influence, section 16. Okay, take for example, as undue influence, you must establish the relationship. One party usually is the dominant figure. Um, Teacher-student relationship. Okay, solicitor-clients relationship, doctor-patient relationship. You can see, so these are the things that you have very poor bargaining powers, what? So whatever he said, you agree lah. Okay, so you're under undue influence. Of course, if you want to argue further, if you are very smart, you can argue the presumed undue influence or the actual undue influence. That one is up to you lah. But for the purpose of this class, section 16 is very important. It highlights when you enter the contract, you must not be subjected to some sort of undue influence. And section 17, of course, fraud, penipuan. Okay, it should not happen lah. And misrepresentation. So fraud is something that with dishonest uh, dishonest intention like that, you purposely know that something is not right, but you cheat. That is fraud. If let's say, for example, you just make exaggerating version, you know that your phone itself is being used for 1 year, and then the battery is the consumption hours, probably it will last about just maybe 6 hours, then you have to recharge again. You go and tell the buyer that, oh, this battery is as good as new. Some misrepresentation is there. No doubt it lasts for hours, but then you say as good as new and lasts for many hours. So you induce the party to rely on your statement and buy. So it will form as a misrepresentation under your section 18. And E will be mistake lah. Either it is a mistake of a law or affects itself. Sama ada kekhilafan tersebut adalah sesuatu berdasarkan kepada undang-undang ataupun fakta. Okay, it has got two. So your general approach, how do you, whenever you see a misrepresentation, don't just write misrepresentation straight away during the examination. You will look that you do not argue the question wholly, So you must first of all define what is the scenario, what is it? Okay, what had happened inside the question? I'll guide you later lah in our coming class. And what is the impact? If you want to say some sort of this apa, A to E had happened, what is the effect of it? Again, you have to rely on your section 19 and section 20 of Contract Act. It does not just finish at misrepresentation itself. Not, it doesn't work that way. And what are the remedies that you are seeking for? Because if you use this sort of course of action, you want to base your course of action on a misrepresentation. So what is the if I mean what actually you want to void the contract or you want to seek compensation? Is two separate remedies, okay? Because the amount is different. For example, if you are seeking it to be voidable, that means whoever received the benefits must also pay back. Sometimes how to pay back? Because renovation, construction, you're already halfway. So the other parties also can claim for quantum merit. Banyak susah. So you must be a bit smart lah. So remember the approach that I told you. And remedies that you are claiming is based on the specific section of the law also. Section 65, 66, 76, or 73. Okay? Very, very important. But I'm afraid this is the most confusing part of the Contract Act itself. Okay? Okay. We try to talk about section 65 first. Okay. Section 65 itself provides that a rescission of a voidable contract, because whenever you have some vitiating factor, the contract itself becomes voidable at the option of one party that suffered from such loss. Okay, so when we discuss about section 65, um, how to not to perform this contract is only by discharge it. That means you perform the contract duly, habis, or it is frustrated, or the court need to give a rescission order. No need to perform. So this is what it means by rescission. You need not perform any promise therein contain party receding to restore benefit and advantage received. Okay, not covering compensation. That means to say you have to restore the benefit. Take for example, if let's say the Rolex watch example, I sell it to Christy for 8 ringgit. But subsequently, because of our relationship, she was my master. She pressed me lah. I claim undue influence after I complete my pupillage lah, of course, obviously. So, how do I say it? My free will, my free consent was vitiated by undue influence because Christy, at the material time she bought the watch with 8 ringgit, she was my master. I have no choice but to submit to her request. So this is my version. But if I'm to rely on section 65, I want to void it. I also need to return 8 ringgit to her. And she has to return the Rolex watch to me. So this is what it means. We call it rescission, okay? Or restitution, restitution. Okay. So section 66, it provides the contract becomes void, you know. Unfortunately, in Malaysia, the case by right, if it is void, it should be illegal contract that can be void. or some sort of contract that is unlawful consideration one only can become void, But some or rather in Yong Mok Hin against United Malay State Sugar Industry, Section 65 and Section 66 seems can be used interchangeably because avoidable contract at the option of the party that suffer losses, isn't it? Will eventually become void. I'm repeating myself. Avoidable contract means the contract can be void by the person suffer loss. But ultimate result is the contract becomes void, dibatalkan, nullified, ada contract. So that's why Section 66 can be used in voidable contract as well. So any person who receive advantage must restore or to make compensation to the person from whom he had received the benefit. So you can use the case of Yong Hin or Satguru Prasad case. Landmark classical case up to now still used in our current practice. Okay. And Section 76, okay, provides one further limb, satu cabangan baru lah, for you to claim compensation. Just now, is take for example, the Rolex watch is being returned to me, 8 ringgit returned to Christy. Habis cerita. This is what it means by restitution. But somehow or other you have another, but you want to claim more for yeah, yeah. How do I put it this way? You have to maximize the interest, the party that you represent, isn't it? As a prudent and reasonable lawyer here. So you have to use one more limb to expand the contract. You cannot just restitute. Restitute means at the end of the day, maybe both parties also feel that there's a gap, a waste of time here. So Section 76 here provides a remedies for person who rightly rescinds the contract. You can claim further compensation, okay, for damage sustained through non-fulfillment of contract. Take this as an example. You appoint a contractor to renovate your house. Bulan berapa now is the bulan February. So for example, before Christmas lah, you appoint that fellow. Okay, that time you import a lot of things, and then you have already you want to save your costs. You import a lot of things from Taobao or China. Okay, so you have already bought this sort of decoration. Suddenly, this fellow here cannot. There's some vitiating factor that make the whole contract void. But then you already suffer some damage already, through the non-fulfillment of this particular contract. So from restitution, that means the cost of the payment, 200,000, you ask him to pay you back, yes. But additionally, what about the the decorations you already bought for the purpose of that renovation? You also can claim if it is within the contemplation of parties. This is by your Section 76. Provided it is not on the grounds of fraud or misrepresentation. If it is under paksaan, under undue influence, and one more is mistake of the fact, you can claim further compensation. Okay, and you must not use this Section 76 ever and never in the case of fraud or misrepresentation. Very important. This is based on Abdul Razak uh, against Shah Alam properties. Okay. Okay, so there are some specific section that you can use, whereby Section 73 Contract Acts provide that a person whom has been paid or anything delivered by mistake or under coercion can ask the payment. Okay, this is a rather specific uh, proviso of the Contract Acts. Okay, we'll discuss one by one the reshaping factors here. Again, I bring to your attention, you must approach it by way of definition. Second, the effect of it. And third, split your remedies. Okay. Coercion means paksaan lah. Okay. So you have to always open yourself in the answer with introductory statement. Section 10, 13, 14, which discuss about the free consent of the individual. And subsequently, you have to use your section 15, define coercion. That means to say you are being threatened or somebody is about to commit a penal code, pukul awak lah, or try to kill you if you do not sign, something like that. This is not uh, allowed by the penal code. Okay, or unlawful detaining or threatening to detain with intention to cause any person entering into an agreement. Okay, take for example, if you do not sign, you shall never leave this room. Ah, obviously you have no choice, isn't it? Malaysia law also recognize economic duress. Economic duress usually supplier and also some sort you are being suppressed lah. If let's say you do not agree to my new contract that this good I increase the price, then I don't supply these goods to you lah. Let you sendiri tak ada barang mau jual. So you are under economic duress. You can see under this case of hydrotech engineering. So what is the effect of coercion? You have to refer your section 19 sub rule 1. Okay, so whenever you discuss, I already make things simple for you. You must jot down all these sections 10, 13, 14, 15, 19, sub-rule 1, and the remedy, section 73. Okay, so what is the effect when coercion happen? The agreement shall be voidable. Okay, at the option of the party whose consent is so caused. That means to say, if you force me, I was the party that being forced, I can make this contract void. Okay, try to understand that. And remedy is section 73. You can ask that person to repay you the money received, the liability. Okay, Chinambi development against Tan Kim Chu here. Okay, and what is that? Okay, this one is one of the example lah. So one day in Singapore, Mr. Gan had threatened to punch or unlawfully detain or threatened to detain any property of Chi with the intention and cause Chi to enter into an agreement with him. So such an act amount to voluntary causing hurt, which is forbidden under Penal Code, your section 323. And you can use the case of hydrotech engineering. So how you answer is like that. Okay, it is submitted that coercion is in existence of as a matter of fact. So coercion will bring the effect of recision at the option of you. So use section 19 as I have told you here. Okay, so you drop your answer like that. Okay, 19. Here also 19. So that means to say Chi can choose whether to continue the contract or to rescind it. That is the meaning of voidable. But if you uh choose to continue the contract, subsequently you cannot say the contract is not exist, because you affirm it already. So subsequently, section 73 Contract Act will be the remedy. Okay, restore benefits. Okay. This is how a very simple example go. Okay, for coercion. Undue influence, also same, define what is it? Effect, remedies. Okay, you do not need to go up to the point of as actual or presume undue influence. All you need to know is you have to put down the wording of your section 16, whereby one party dominate the will of other and unfair advantage. Bargaining power is not equal here. Okay, there must be some kind of relationship or mental capacity to be presumed. And the burden of proof in issue, you can rely on a case of polygram record against the search lah. And what is the effect? Effect, you can find it in section 20. Okay, voidable contract. Okay, that means the person that suffer undue influence, like the Rolex case that I have provided you, I suffer undue influence, so I have the option whether to affirm this contract or to make it void. And your section 66 provide the remedy, restore or make compensation. Okay, you can rely on the case of polygram records against the search here. Okay, all right. So one example, opening with section 10, 13, 14. Uh, Again, it's the same here. Free consent, very important. Section 10, okay, exists between two parties, gun and cheat, based on whatever your scenario lah. And you must submitted that the fact suggested that the free consent be vitiated by undue influence. So make your standard opening here. Then you describe what is the facts of the case. So this is one of the sample. Mr. Gunn, an elite hedge fund manager from Wall Street, had approached Chi, who is used to be his good friends. Okay, see the relationship. Okay, and also see the position here. It had been unfortunately, Chi suffered from dementia due to old age. So Mr. Gan took the opportunity to sell his platinum investment package to Chi, who was demented. At the end of the session, Chi concluded that he believed in Gan and signed up the investment plan worth 1 million ringgit. So pursuant to section 16 subrule 1, it was Mr. Gan that is in a position of will that can dominate the will, of Chi. Because I'm not well, I rely on his position as hedge fund manager from what we call Wall Street some more, and he's my friend. So he obtained an unfair advantage. There could be a presumed undue influence, judging at Gan's profession as hedge fund manager. So use section 16 subrule 2. So Mr. Gan will bear the legal burden of proof to rebut that presumption. So everything inside the court, we have to produce evidence unless there is a presumption and unless there is an admission. So whenever there's a presumption, the burden shifts to the other party to rebut with facts. Okay, so this is how it plays out. And it is submitted that undue influence is in existence as a matter of fact. Undue influence would bring the effect of recision at the option of Chi. So you use section 20. Okay, Chi can either choose to continue or to rescind the contract. Okay, so this is one of the drafting lah for your answer. Okay. So in the event Chi opts to rescind the contract itself becomes void. Following the case of Yong Mok Hin, it is suggested that Section 66 containing when a contract becomes void cover the case of a voidable contract. So because ultimately a voidable contract, like I said, what is the end result of a voidable contract? It shall become void. So section 66 also can be used. Boleh diguna pakai. And it is submitted that section 66 is applicable in Chi's case. whereby guns receive advantage must restore and make compensation. So not only that, I want restoration, like I've told you, you need to maximize the interest of the party that you represented. Okay, so you go one more leap further. Okay, so fraud, very popular question. You must know it detail. So what does it mean by fraud? Fraud is defined under Section 17, okay, Contracts Act. It includes any of the following acts committed by a party to a contract or with his connivance or by his agent, whatever his affiliates lah, his agent, his members, his directors or his employees with the intention to cheat. Very important, this keyword. Act dishonestly, okay, deceive another party thereto or his agent, or to induce him to enter into contract. So there must be some element to cheat or to defraud. Okay. So A, the suggestion as to a fact which is not true by one who does not believe it to be true. That means to say you knowingly dishonestly deceive a person, whereby you yourself, as a matter of fact, know that it is a lie. It is absolutely not true at all. Okay. The active concealment of a fact. Okay. If you have a knowledge that there's a huge defects in the house, the house is already cracking and then the water is leaking, but you conceal it before the buyer come to the house, you purposely ask a person to fix it. So when it's raining, it doesn't drop. But in fact, you know that it will not withhold that long. So you conceal the fact. Okay. And a promise made without the intention of performing it, just like the one that I give to you, this example, you induce people to open cafe, but in fact, you actually do not want to open at all, but you want the money, the investors' money. Okay. And any act that might be amounted to cheat, okay, shall be considered fraud lah. Okay, or omission as per the law declares it to be fraudulent. Okay, take for example, you memang the law already said this is uh, fraudulent in nature. Okay, so you must find a suitable slot lah. What is the when you plead fraud in your answer, find what kind of a scenario, which section that fits in the description that you are putting forward. And as usual, you must discuss what is the effect of fraud. Okay. You have to look at your section 19 subrule 1. Okay, if it is section 19 subrule 1, an agreement is caused by fraud, the agreement is voidable at the option of the party whose consent is to so caused. Okay, first it talk about the effect. When your free consent to enter the agreement is actually vitiated by fraud, the said agreement is voidable at the option of the party that suffered or being cheated lah. The party that got cheated can make the contract void, but it's subject to uh two exceptions. Very very important. There's a rules called what a caveat emptor. You must exercise your ordinary diligence to discover the truth. Take for example, just now I said to you the phone I sell to you. I said this is good in function. In fact, knowingly, I know that this phone can't even on. As a reasonable and prudent buyer, by right, you should take over the phone for ordinary inspection, isn't it? You should have at least try and use it, open some app, and to see whether it is burning in sensation, or whether the music can be played or not, whether there's some faulty or not. So this is the truth that you can discover. What you cannot say I cheat you. I would definitely in my defense say that I never cheat you. You never check. I put the fault on you. So this is section 19 exception, which you must know it very well. Okay, and the second exception would be if the said fraud is not the reason you enter the contract. Let's say, for example, I cheat you, like I cheat you, but the reason or the lies that I made to you is not the sole purpose or the sole reason that caused you to enter into a contract. Okay, so this fraud itself, yes, it exists, but the whole contract cannot be voidable. You get me? So that means to say the party entered into a contract from some other reason. Okay. Uh, and the balance of proof now is on balance of probability lah. The standard of proof, sorry, is on balance of probability. Okay. So this exception you must know in detail. Okay. Remedies, you can use section 65 Contract Act. So you rescind the contract, you say it is void, and then restore benefits. And subsequently, you can also use section 34 subrule 1 Specific Relief Act, okay, whereby it provides that where a contract is voidable or terminable by plaintiff, such rescission can be adjudged by court. That means to say the court can declare the agreement is being rescinded. They can give a rescission order. Okay. And section 37 Specific Relief Act further provide that court may require party receding to do equity. Justice must prevail. There must be fair to both parties. Okay, so these are the powers of the court. Sometimes you renovate halfway and then you say that this agreement is a fraud, the quality of the uh, renovation materials are not so uh, in accordance to what had been promised, and then the contractor is using some some fake counterfeit products instead of original one. So that means there's some dishonesty component, but still you cannot say that you did not enjoy any benefits, isn't it? Even though, let's say, for example, can I use as an example the LED light lah. By right, it should be one good brand here, but they use a counterfeit brand made in China. But still, you are getting the lights, isn't it? So the court can do justice, by asking you pay partial amount of renovation cost to contractor, even though there's a fraud element, even though you uh, plead for restitution at the end of the day. Okay. So for outline, again, start with opening, very standard lah. This one is standard. And you use the scenario. Okay. So why you plead fraud, you must fit in the scenario given in section 17A, B, C, something like that. Why you plead fraud, there must be a reason. You cannot simply write in your answer, oh, yeah, because there's a fraud inside the question. So you just happily write, oh, there's a fraudulent. But why? Your answer must show that you interpret the law and also you interpret the facts nicely. Okay, so you can read it at your own time to see how I draft the answer as a example to guide you. Okay, opening, scenario, and why you said so, and what is the effect, what is the impact. Okay, so and also you must find out whether the plaintiff here exercise due diligence or not, or even if the due diligence is being exercised, there's no way for you to discover the truth. Okay, something like that. You must put in your answer. Okay. So this is one of the answer. I basically cover, usually my outline of the answer, I cover all the relevant section. So at least you can secure a pass mark, okay, for your examination. You must, for the sake of completion, you must do like that. I think will be better. More secure, okay, more secure position you have. Okay. Be clear, Section 76 you cannot use in the case of fraud or misrepresentation. Okay. So misrepresentation, okay. Again, define what is it? Effect, remedies. Okay. So misrepresentation, uh, like I said, Malaysia has got Contracts Act, isn't it? So do not go and waste a lot of time argue fraudulent misrep lah, innocent negligent misrep. No need. To me, misrepresentation is clearly defined under Section 18 Contracts Act, which includes a few keywords here. There must be a positive assertion by the party, okay, and in a manner not warranted by the information of the person making it, which is not true, though he believes it to be true. Like the Tanjong Motor example, the salesperson has no element of cheating because he himself is made to believe that the Nissan car can be exported to Australia. Somehow or other, this is not true, but he did not check with the custom department of Australia. You cannot say fraud, ma. So you can use misrepresentation here. Okay, so any breach of duty without intent to deceive, very important, okay, give advantage to the person committing it, mislead other, which cause him to suffer loss lah, or prejudice. Okay, and causing, however, innocently a party to an agreement to make mistake as to the substance, which is the subject of the agreement. The best way that you can memorize this section will be Tan Chong Motor against Alan McFly case lah. Okay, just remember this is a car agreement. One of the collateral contracts said that it can be exported to Australia, and then the salesperson has no intention to cheat, but rather because of this misrepresentation, this positive assertion, the Alan McLeod rely on this statement or the term, okay, and he bought the car and he suffered loss because the car cannot be exported to Australia. So complete answer and complete definition for section 18, section 18. Okay, compare with English law, no need lah. I think fraudulent misrepresentation, a lot of case law in Malaysia already said it's been codified under section 17 already. So no need to discuss. Negligent misrepresentation, you see, there's a breach of duty here. So the duty here probably will refer to duty of care under the cautious law. So you do not also need to specifically talk about um, negligent misrepresentation specifically, because sometimes you can be wrong. So if I were you, I would just put misrepresentation rather than act too smart, because contract law so you want to say negligent Huh. Unless you are very clever lah. I mean, how to plan talk. If you're just ngam normal student like me, I will just make sure that I play my rules safe, okay, rather than going misleading the examiner. Okay, innocent is also being codified in your section 18C. Okay, innocent. Discuss the statutory provision enough lah. Do not compare and elaborate in length of your English law. Okay, again, you have to look at the effect of misrepresentation. So what is the kibat ataupun impact misrepresentasi tersebut? So again, standard rule, whatever affect the free consent is voidable at the option of the party. And misrepresentation, just like the fraud, is subject to two exceptions, which are extremely important. If you could have discovered the truth with ordinary diligence, that means to say it is within your specialty, within your expertise. You see it, or you just do a checking in a very minimal cost and efforts, you will not be cheated or you will not be induced to enter into this contract. You cannot rely on misrepresentation. Okay, so this is one of the exception. And second exception is just like the fraud also. If the misrepresentation did not cause you to enter into this contract, take for example, you bought the car. Take for example the Alan McLean case. I bought the car because it is cheap price. Misrepresentation is not the cost that I enter into a contract. I clearly said that the price is very reasonable. I love the car. I love the design. Okay, so there's no way for you to argue misrepresentation later. Okay, taking example lah. Okay, so remedies you have is 65, 66 Contract Act as well as your section 34 sub rule 1 of your Specific Relief Act. Okay, you can restore plus compensation. Okay, restore plus compensation. And section 34 sub rule 1 means that the court can give recision order. Okay, why is that so? You must have a recision order from the court. Very important, because if you do not perform, still go back to the equity principle of the contract. Every contract shall be holy. You must execute whatever the terms and also the conditions of the contract. So whenever you want to declare a contract to void, you may want to put a rescission order as well, so that your plaintiff, party that you are representing, is discharged of his further duties to perform some subsequent contracts, because some contracts will be very complicated. It's not just one consideration, multiple things, So you have to discharge further liabilities. Otherwise, if you meet a very smart lawyer opponent, you do not plead, yes, okay, never mind. Subsequently, I sue you for a new cause of action. You breach the contract. Susah lah awak nanti. I mean, later on, you also very hard to explain to your client. Okay, so make sure you know the law very well lah. And this is one of the drafting that I put forward to you. You can read it at your convenient time, about how to draft and how to outline apa nama this one into your answer, or into your answer. Okay, it's just repetition. I hope my explanation is clear enough for you. Okay, so case refer, you can put it in this manner also, doesn't matter. Okay, and mistake khilaf means membuat satu kesilapan, kesalahan tentang pemahaman. Okay, there's no definition, but it is broadly classified into operative mistake as to prevent the formation of contract. That means to say there's no consensus in them. And like I have described to you, mistake is something that, as pursuant to the subject matter, usually see shipping case lah. Like last time, communication is very very slow, isn't it? You don't even know that the ship is sinking already. So you make a contract because you want your turnover sales, ma. Take for example, my goods are still in uh evergreen punya ship, big ship is in Pacific ocean. It is about to come to Auckland on take for example 26th lah of February. But I made the contract with you on January during shipping. Assuming that there's no handphone, there's no advent of technology as in today, I wouldn't even know the ship is sinking prior to its arrival, isn't it? So I made a mistake as to the fact when I enter into a contract, if the ship that carry the goods already sank into like a Titanic, already sank into the ship during the contract. So this is kesilapan lah, fakta lah. So you don't know what. So this will be your reshaping factor as well. Okay. And so you have two. Facts is the one that I've said to you, section 21 Contracts Act, and you make mistake of to the law also can. Okay. So you have your English law position as apa nama, as if you make mutual mistake or common mistake or unilateral mistake as to the facts itself. Apa fakta, apa subject matter that you commit a mistake. Usually it is what, this one. Res extincta, the assistant of the subject matter. Okay? Like the goods in the ship already vanished with the sinking event. Okay, the ship capsized, for example. Resoir, okay, as in the possession or the ownership. Like I said to you, it rarely happens. Usually now counter check, technology change, a lot of law also. Last time, you don't even know your title of the house. Uh, I mean, nowadays very fast lah. You can do online land search and all that. Last time it take months for you to produce a land search. You don't even know the house is being transferred, or you no longer you are not the owner to enter into a contract. So you make mistake. Okay. And the third one is as to quality of the subject matter. Okay. You make a mistake. You can plead so lah. Okay. So, law one, okay, take for example, if you have, you follow this flow chart, okay, you have to categorize whether it is a mistake as to facts or it is a law. Okay, if it is a fact, you have to see both parties made mistake or not. If both party made mistake, then it is void. Okay, common understanding. That means it is a common mistake or it is a mutual mistake. Okay. That means to say the contract tak ada lah, dibatalkan. If it is just made by one party, as in I'm the supplier of the goods. Only I made mistake. But the buyer here has a genuine knowledge that, for example, he did not make a mistake. It's not his fault lah. Take for example, he did not even know the shipping or that. He assumed that I have the goods now, and I also did not represent to him that the goods is in the shipping process. So this is called unilateral mistake. I did make mistake, but the other party did not. What you get me? So unilateral mistake, I have yet seen any case law yet. But by virtue of English law, it is void. Okay, but somehow rather it's a little bit clear lah, because one party only, one party. But this is not so important for your examination. Your examination, I think, fraud and also misrepresentation are more important. Okay, if let's say it is a mistake as to the law, okay, if law is not binding or enforced in Malaysia, then it will the same flow chart as to the fact will apply. Okay, it depends whether it is a mutual one or just unilateral. But like I said, it's unclear lah. Malaysia's law said that this is not voidable, but English law say void. But I cannot find any case law to support my position lah at this moment. Okay, if let's say it is law enforced in Malaysia, by right, it is not voidable. Having said so, that's why usually contract, if it involve a large amount of money, better engage a lawyer. If not, nanti, if let's say, for example, you make a mistake to the law as to the subject matter, the other person can also ask you to execute it, because it's not voidable. And it is a possibly valid contract. It means to say the other party can use this contract to enforce in the court and sue you. Okay, so that's why it's important lah. Okay, so remedies wise, you can use your section 66 or section 73. I repeat myself, a lot of times in regards to this two particular section, you must have a look on, at your own time. If you do not have time to read, you just rewind back what I said. Okay. If let's say, for example, you make a mistake, you can always ask for the campur tangan mahkamah. We call it intervention of the court to declare whether this contract is void or not, because you want to run away liability already now. You know that you sudah buat satu kesilapan. Before the other party sue you, you might as well as the court for ratification of some declaration. Okay, so this is ratification of the instrument under your section 30 to 33 specific relief act. I have to admit to you lah, so far I never see any cases lah make mistake, because everybody uh, as a lawyer now very careful in their practice. Okay, and legality of the contract will be our final discussion tonight. Okay, so legality of the contract, you must start with section 2G, the one tongue twisting one that I told you earlier, 2G, okay? And section 24. Section 24 got A, B, C, D, E, be specific, must be specific, which limb that you want to rely. Cannot in your answer just 24 lah. Okay, 24, you bleed, yes, I'll give you mark, but probably not an outstanding mark. Okay, so Section 24 Contracts Act said that consideration and objects are lawful unless forbidden by law, prohibited by law, defeat the law, okay, fraudulent in nature, causing injuries to any party, and against public policy. This is something to do with the interest of kepentingan awam lah, kepentingan awam. Okay. So memorize one case here. Merong Mahawangsa Datuk Shazri SK. One of the past year question is entirely based on this case. Okay, very important. Still we are using up to today. Okay. And legality of the contract. The agreement will be void if the consideration are unlawful in part. Even of the consideration itself is unlawful, it shall be void as a whole. Okay, it shall be void as a whole. So this is the strict attitude of Malaysian court towards, you cannot do illegal activities in a very short term. Okay, take for example, I engage you to sell coffin in a large quantity. At the surface of it, you look at it, to sell caffeine, okay? You're just selling some sort of stimulant, just like coffee, isn't it? But if you are selling it in a large quantity, by right, you are infringing the Poison Act, Okay, so if you are infringing the Poison Act, let's say, for example, even you sell coffee also, probably it could be unlawful in part. if let's say the quantity of the let's say you draft contract, you sell coffee, all that, but the quantity itself is unlawful in part, you cannot enforce it. Okay. And you have subsequent provision like section 27, restraint of marriage. You cannot uh usually it happens in a Chinese or Indian family, or you cannot marry uh with him. You must marry with my appointed person. Okay. I already make so-called engagement, marriage engagement when you are small with my rich friend son, like that. Therefore, you cannot have any boyfriend, you cannot marry with somebody. So this contract is also void. Okay. Mm. And you can see a lot of artists, pop stars, celebrities. Okay, you can see the case of Shaw Brothers. They will have a clause saying that during this contract of period, you cannot get married, you cannot get pregnant. So to ensure that their marketing, they invest on you, isn't it? They do the branding for you. You become popular, suddenly you go and marry a rich guy. So somehow or other, this is not fair also to uh the company, the what we call the star recruitment company, isn't it? So they will have such clause, but this is not enforceable in Malaysia. Okay. But somehow or other, every rules will have some alternative alternative to go around it. Okay. And section 28. Section 28, very popular, restraint of trade. Usually it applies in employment contract. Okay, take for example, I hire a lawyer in my firm, and then I pay him or her 10,000 per month, okay, high salary, and then I teach her a lot of things during the practice, and then I put a clause that you cannot open 10 km radius within where is my established Chris and Partners is established. So this is considered a restraint of trade already. You get me? You cannot be practicing as a lawyer. Take for example, 2 years post termination of this employment contract. So this is restraint of your profession. So this is void, void. Unless three exception. This one also remember for practical purpose a lot of case like this one. So the exceptions would be if you are selling it for goodwill. Take for example, I bought over Chris and Partner from Christie for 1 million ringgit. And then I put a clause of restraint of trade. He cannot open 10 km near me. This allow, because I bought from you, Chris and Partner, suddenly you open beside me and snatch away my business. So cannot lah. You sell for goodwill, okay? And an agreement between the partners prior to the solution. Okay, take for example, I joint venture with somebody to sell bubble tea, milk tea lah. Okay, uh, and then suddenly I see the sales are wow so good the sales in Bukit Bintang, take for example. And then during this partnership, I open up a cafe just beside him, beside the same joint venture shop cafe, just to take because I share with people I the sales are so good. I also want to cut 100% to myself. So that clause, if it is ever existed in the contract that entered between parties that talk about restraint of trade, it is enforceable. So these are the apa nama? The three exception here. You cannot doing business and then and try to make some sort of profit, okay, by yourself lah. This is what is the purpose of the law here. Okay. And if this one usually where this one hospital they'll have a admission before the admission, they'll sign a lot of contract lah. Oh, one of the popular clause is the hospital shall not be liable for any damage, injury that you have suffered during the admission, and you cannot commence any legal action against us if you suffer from injury. So that clause will be fall and will be caught under your section 29. If you stop people from suing you in this contract, automatically it is tak boleh. It is void. Okay? Remember, okay. Unless it is subjected to three exception. Okay. First, if it is being referred to arbitration. Okay, this is under your Arbitration Act 2001, Section 10. If let's say the contract itself has got a clause, you cannot commence any action against me in any court, but you must refer the matter to arbitration for settlement. This clause is okay. You get me, Because Section 10 Arbitration Act 2001 is a very powerful section that it can cause the English word I forgot suddenly. The suspension of the case, the pergantungan case. Pergantungan means the whole case shall be withhold, should be paused if the case is being referred to arbitration and there is an arbitration clause in the contract itself. Okay. Second, again, is the arbitration, and the question is already being arise. Okay. And third exception is between government for for example, for award of scholarship. Okay, let's say the government suddenly don't pay you because your results are very poor. It will have let's say you don't score B and above, somebody will never pay you. I mean, the whole scholarship agreement shall be terminable by the government, and you cannot commence an action against the government for breach of contract. They will have this clause, and it is allowed to protect the government interest. Otherwise, first of all, you get STPM, you get 4A. But subsequently, during your university time, you watch movie, you go lepak, you don't really concentrate on your studies. How? Like that, Okay. So these are the three exceptions. Okay, an agreement by wager void except legitimate horse racing. Okay, so this term is quite self-explanatory lah and hardly used in our practice now. So universal effect of an illegal contract the contract shall all be void. It's not even voidable. Okay, must distinguish. Void means nullify ab initio. From the beginning, you enter the contract, it is gone already. Tak ada contract langsung. Okay, so universal remedy for legality, let's say illegal contract is comparatively simple because you can only rely 66 restore. Okay, make compensation, as simple as that. Restitution. Whoever that get benefits, pay the other party back. Okay? Oh, finally, we come to an end of our session. Put a pause.